Please be ready for dictation of transcription number 305 from Sir Kailash Chandra magazine. It is an extract from the speech of the Honorable Law Minister made in the Rajya Sabha on 23rd December 1977. 5 seconds to go. Start. Sir, I beg to move that the bill further to amend the Constitution of India as passed by the Lok Sabha be taken into consideration. Sir, I am very happy to say that so far as this item of the business is concerned, it is free from any acrimony of any kind. Sir, the contents of this bill have received universal support throughout the country and in the other house, as is known to all sections of this house. Sir, I will very briefly indicate, although it is hardly necessary to do so, as to what this bill is about. Sir, first of all, as is known to all the honorable members of this house, a provision had been introduced in the Constitution in the shape of Article 31D by the 42nd Amendment Act, by which a power had been given for banning the so-called anti-national activities and anti-national organizations or associations. Parliament had been given the power by that provision, which had been introduced in the Constitution, to make any law and to impose any kind of restriction on the people of this country which could transcend the fundamental rights guaranteed by the Constitution and contained in Articles 14, 19 and 31 of the Constitution. Sir, this was such a blanket power that the inclusion of Article 31D had come in for universal condemnation and criticism throughout the country. I am very happy to say that this is an attempt to redeem the pledge which had been given by the Janata Party to the people of this country. Of course, the pledge goes into various other matters also, which are still at the stage of discussion with the leaders of various political parties in the two houses. But so far as this is concerned, this particular proposal to repeal Article 31D and to delete it from the Constitution was universally and unanimously accepted. It was realized that it was not necessary to give such drastic and draconian powers at the cost of the fundamental rights, at the cost of freedoms enshrined in Article 19, and even at the cost of the fundamental right to equality guaranteed by Article 14 in the name of anti-national activities and anti-national associations. I am thankful to all the honorable members for their unanimous support to the proposition which is being made by this bill. Sir, the other provisions of this bill are equally non-controversial, as the reactions in the whole country of all sections of people, of all political parties as reflected in the proceedings in the other house, have already demonstrated. Now, sir, certain provisions had also been introduced by the 42nd Amendment of the Constitution, which dealt with the powers of the Supreme Court and the powers of the High Courts, as well as the mode of exercise of those powers in those courts. Sir, it had been provided by the 42nd Amendment that High Courts cannot consider the validity of a central law. The definition of a central law did not confine merely to legislation. It included even a statutory notification, with the result that virtually whenever any important exercise of power by the center was to be challenged, then in that case the High Courts had been deprived of their power to sit in judgment over the validity of either a central legislation or a rule enacted under the central legislation, or even a statutory notification made by the center into those laws. Sir, it is well known that India is a very large country. India is also a country of poor people. If the High Courts, which are important courts exercising jurisdiction inside a state, are deprived of their effective jurisdiction of granting relief against the illegal exercise of powers in the shape of central laws as so defined, and a person is compelled to get relief only through the Supreme Court, then, sir, the position is that this remedy of getting relief against orders, against rules, against laws which might unfairly affect the rights of citizens is virtually taken away from those people, because many of these people in a poor country like India, in a country of such large distances, do not find it possible to get a proper relief from the Supreme Court. So, sir, while the powers of the Supreme Court had been preserved, virtually an impediment which was difficult to cross for so many citizens of this country had been placed in the way of obtaining justice on behalf of innumerable citizens of this country. So, sir, an effort has been made by this bill to remove that impediment from the path of the citizens of this country, so that if anything wrong is done in the form of any law, whether it is legislation or any statutory notification by the center, the easy method of obtaining justice in the High Court itself, which is more easily accessible to the citizens of India, may be open to them. Stop.